I was trying to do.
Okay, well, let me just finish. So it came on an ex parte request filed by Marcy Allen, not Marcy Lutsky. And I went through this with Miss Allen or Miss Lutsky this morning. I think Miss Allen, you and Miss Lutsky are one and the same. Is that fair?
Yes.
Yeah, okay. So, so I had this ex parte request, and on the phone, is this Mr. Chandra?
Yes, Your Honor. Sam Chandra appearing for plaintiff, Breckenridge Property Fund 2016 LLC. Thank you.
Okay, so I have a proof of service that a process server served some documents on you a couple days ago, but it was kind of unusual. So we called you your office this morning because Miss Allen, Miss Lutsky, said that she had called your office yesterday to let you know about this hearing, and you weren't here. So, go ahead.
Thank you, Your Honor. We did receive documents. The only indication on the notice is that it is in courtroom 22. I believe the proof of service reflects the hearing date, the time, complaint date, and all that is blank.
Yeah.
We did receive a call from Ms. Lutsky, and she was asked to please hold so that from the receptionist, but when the person trying to take her call picked up, she was no longer there.
Okay, so let me just say this. I don't know what you have, but I've got a whole bunch of documents, and I'll just try to summarize them for you just real quick. That this is an unusual situation. I have, for instance, I have a document entitled Sworn Declarations in Support of Ex Parte Motion to Vacate Default Judgment and Ex Parte Motion to Stay Execution of Unlawful Detainer. And I understand that the lockout is set for tomorrow morning. And if you got a second, I just want to go through this with you to make sure we're all on the same page here, because there's a couple of unusual things. There could be a completely innocent answer to them, but I'm just not sure. I don't have enough information in front of me to address the merits of this case. Technically, I just have a 473 in front of me, which would be, was there any kind of mistake, inadvertent, surprise, excusable neglect for Ms. Lutsky not to file an answer? Has she acted diligently, and what is the prejudice to you? Okay, so can you bear with me for just a minute?
Yes, Your Honor.
Okay, because Ms. Lutsky tells me she's been living in this house for 16 years, and it looks like her adult daughter is maybe in the courtroom, and I just want to make sure that I'm getting this right. So you filed your unlawful detainer case on October 31, 2017. It was a post foreclosure. There's a trustee's deed attached. The trustee's deed doesn't show who the foreclosing party was, which I'll explain to you why that's kind of not problematic, but why I mentioned that. I believe that she was served on November 4th. Her husband was, or former husband, whoever Mr. Lutsky is now, he was subserved, and you defaulted both of them on November 27th. However, and I can verify this because there's a note in the file, she did go to the clerk's office on November 7th before she was defaulted and tried to file some documents. And the clerk's office rejected them. Not sure why. My guess is because she submitted them in the name of Allen, and maybe not in the name of Lutsky. Maybe the clerk's office wasn't sure what to do with their paperwork. So that's the status of this. Then you finally, this is another unusual thing about this case. Even though the default judgment was entered on November 27 and you had the writ issued on November 27, for some reason, my guess is the paper didn't go to the sheriff's office for another 45 days or so, which is unusual. I'm not sure, why that was the case, but that's what happened. So just let me tell you what I've gleaned by looking at the paperwork that Ms. Lutsky has presented. Apparently, in May of 2004, she and her husband obtained a loan, signed a deed of trust with Wells Fargo. The deed was recorded, and she showed me some documentation with the canceled check showing that the loan was paid off on March 14, 2017. Then, on May 30th, there was a notice of default filed by who I don't know, because the trustee's deed doesn't say who the foreclosing party was. I'll be the first to admit, she could have had a first and a second, she paid off the first, and the second was the foreclosing party, I don't know. That's why I'm asking, that's why I wanna talk to you. In any event, the notice of default was on May 30, 2017. The trustee's sale of the house was on October 5. The sales price was, I think, about $525,000. The foreclosing party received about $300,000, and there's a $225 check running around here at the courthouse to be distributed to somebody. Then you filed your UD case after the foreclosure sale. She came to the courthouse on November 7. Her paperwork was rejected. And then this is another thing that's a little unusual. Ms. Lutsky has presented to me a deed showing that your client, Breckenridge, sold the property to a third party, I think it's Champery, prior to the default being entered, which raises the question, can a non-owner proceed with a UD when they sell the property while the case is pending? I don't know the answer to that question. And so the other thing that's interesting, I haven't seen a deed to this effect, but Ms. Lutsky tells me that on September 27, she transferred the property to her adult daughter, and that deed was recorded on October 10th, 2017. So some questions that I have in my own mind is I don't know if the foreclosing party was Wells Fargo or somebody else. If it was Wells Fargo, did they make a mistake? Or did the trustee make a mistake? I don't know why Ms. Lutsky hasn't presented me with a reconveyance from Wells Fargo when she tells me she paid off the loan. I don't have a deed from her to her daughter. I don't know what the significance of that might be. And that raises also the issue of the issues I have in front of me today. Frankly, the only one is the 473, and or am I going to stay execution until we can figure out what's going on here, and the prejudice to your client in light of everything I just said. If I was to stay the execution till we set up a brief hearing to see if the 473 should be granted. So do you follow all that?
I do, Your Honor.
Okay, so I don't want to, look, if she's been living there for 16 years, and if there really is a mistake, it could be on the part of Wells Fargo, it could be on the trustee, your client could be entirely innocent. I just don't know. And so I looked at this paperwork. Frankly, it's kind of a mess. I'll be the first to say this. It refers to federal statutes and some other things. But the gist of the whole situation is just as I described for you, I think. Is that correct, ma'am? Okay,
I believe so, Your Honor. I would like to respond to all this.
Sure, go ahead.
Okay. Well, Your Honor, first, I'd like to go into the identity of the person who is appearing before the court and whether or not they have standing. Now, this individual in the documents that I have indicates that her name is Allen, but she refers to Stephen F. Lutsky and Marcy Lutsky as independent parties.
Well,
so
you know,
in her documents,
I get that.
She is not Lutsky.
But I'm telling you she is. And if you look at the paperwork, she references the fact that she's a trustee for oh, hold on a second. Let me see if I can find this. There we go. She calls herself the trustee, comma, ultimate parent. I have no idea what that means, but I'm just trying to look at the bottom line and see if you could help me out with the questions I just posed to you. Okay.
Well, before we get into that, I would want to point out the second deal breaker, Your Honor, and that's that 473 requires that a proposed responsive pleading be filed or the court shall not grant the motion. It's mandatory language. I haven't seen anything that comes close to an answer. I have seen things that contest the court's jurisdiction and says the court doesn't exist and doesn't have the right to enter any kind of judgment against her. But I haven't seen any type of answer.
It's true.
Without that, it cannot be considered.
there is no answer. And when you go through all those things about what the court can do and can't do, the three phrases we always have: the court may, the court shall, and the court must. And shall is somewhere in the middle, but I understand what you're saying. Typically, you're supposed to have an answer attached, but if somebody has a really meritorious reason why they didn't do something and it's obvious, then I think most courts would bend over backwards to try to do the right thing instead of rule on a technicality. But I get it. So what else can you tell me?
Okay, moving on to the transfer of the property. I recognize Champery. That is one of the entities that my client uses. Okay. My client has a parent corporation, and it oftentimes will move properties so that it can refinance them.
Okay, so it's one of the same.
So if,
yeah, okay, all right.
I was going to say that if this is the case, in every instance that we've had one of these where this has been brought up, I'm able to then turn over an authorization document that says that basically that in this instance, Breckenridge Property Fund would be deemed the former owner, now manager to the property, managing for Champery.
Okay. Well, what do you know about who the foreclosing party was? Was it Wells Fargo? Do you know?
I don't know, Your Honor. This is the first time this question has been brought up to me. I see that there's a trustee's deed upon sale, and I didn't dig too much into it other than the fact that this property was sold by the trustee, and typically my client under Melendrez is entitled to a conclusive presumption as to validity of the sale.
Yeah, I'm not...
I don't know about a reconveyance.
Yeah,
I don't know about payment.
Do you have a copy?
I know that if the property was transferred, that it would be subject to any deed of trust on the property.
You mean that when she transferred it to her daughter?
Yes, Your Honor.
No, I'm talking about, do you have the paperwork that you have, I don't know what you have. I suspect you don't have everything that I have. There's some of the stuff I think we just filed yesterday. But do you have a copy of the $288,000 check that went to Wells Fargo?
No, Your Honor, that was not submitted to me.
Okay, yeah, so I have a check here, and it looks like it's legitimate. It's got all the stuff on it. It was issued by Bank of America to Wells Fargo. It was issued on Miss Lutz's account. And then there's a letter here from Wells Fargo saying, thank you, your loan is now paid off. But like I said, I don't know if this is the first and the second is the foreclosing party, or if this is the second and the first is the foreclosing party. And I couldn't tell by looking at the deed of trust from the trustee at the foreclosure sale, because it didn't identify the foreclosing party.
Your Honor, does the check pertain to that property? Is there any indication that the check actually applies to this loan or this subject premises?
Well, let me take a look. I have a, take a look here.
On the congratulations letter, there's a loan number on it.
Just a second. So ma'am, I'm looking at one of these documents a little more carefully. Was this in part of a Chapter 13 bankruptcy case?
I initially initiated bankruptcy when I was in default for a while, and so I did have a sale date, and to stop the sale date, I initiated bankruptcy, but I never proceeded. But the trustee said that they paid off Wells Fargo Bank, and all three of my credit reports reflected that the balance was at zero on my.
Okay, let me just ask you, when you filed bankruptcy, how much was your house worth?
Probably the same amount. It was exactly a year ago.
Okay, how many liens did you have against the house? How many secured loans?
Only one.
Just the one, the Wells
Yeah.
Fargo, no other credit?
No.
Okay, so let me look at, I can tell you this, I have a letter here addressed to the Lutskis from Wells Fargo. It's dated March 28, 2017. It says mortgage account number 0136717477. We even closed the documents he requested with this letter. Here's another doc. Let me see here.